SJC-11971, Salvatore DiMasi v. State Board of Retirement and another.
Good morning.
To you, Mr. Kiley, but give us a second until we're ready to go and can start the clock. All right, we are all ears.
Good morning, Mr. Chief Justice, and may it please the court. My name is Thomas R. Kiley, and for the last 6.5 years, Mr. Marks, Assistant Attorney General Marks, and I have been arguing about the application of Section 15 of Chapter 32 to Salvatore F. DiMasi, my client. The only thing older than any of us in the courtroom today is the statute, Section 15, Chapter 32. It was passed in 1945. As originally passed, it had 3 sections. Those 3 sections included subsection 3, which contained the language in substantially the same form as the language in subsection 4, which is in issue in the DiMasi case. The statute in 1945, the times were very different than they are now. When the statute was passed in 1945, it was a comprehensive rewrite of a system of pension laws that was scattered. It was an attempt to reorganize all of those statutes into a single contributory system. And it had the dominant theme of 1945, as we all might suspect, was taking care of the veterans who were returning from World War II. It did have a forfeiture provision. It was a limited forfeiture provision. In essence, subsection 3 dealt with a situation where a retiree or a potential retiree, a member of the system, had stolen money from the Commonwealth or from a political subdivision.
Was the 45 version the version that this court interpreted in Colados, or was it a different version?
No.
I didn't mean to get you off. I'm just trying to orient myself.
There's no off. 6.5 years, we've seen most of the arguments. In Colados, you were interpreting section 3, subsection 3A,
Okay.
which was inserted in 82.
Okay.
And it is important, Justice Botsford, to recognize the subtle distinctions in the 3 forfeiture provisions dealing with retirement allowances. The wording, though, in no event, after final conviction,
Right.
that language is the same in all 3 subsections.
And that's been there since
1945.
Okay.
And I think it important to note that despite all the time we've had to work on this case, I have found nothing that suggests that prior to Woodward, prior to 87, there has ever been any attempt to apply the statutes prior to the time that appeals have been completed. And this case raises the question that I think is unanswered in Colados and Woodward, which is when a final conviction occurs for purposes of the statutes.
Now, Mr. Kiley, it appears as if you are right, a consequence of it is that if somebody pleads guilty to the offense, then they will lose their pension immediately. If the same person were to go to trial and be found guilty and then appeal it, they could postpone that happening for 2 to 3 years. Why is that something that we can assume the legislature would have wanted to be the law?
Because of the importance of an appeal in the criminal justice system when one is accused of a crime, is the simple answer.
But why would the legislature want to encourage people to go to trial who otherwise would plead?
The legislature, in dealing with pensions and retirement law, is dealing with expectations of employees, people coming into the system and seeking to induce them to join and continue service for a number of years, as Mr. DiMasi did in this case. The look when an employee is coming into state service is not down the line, you're gonna plead guilty to an offense, or you're gonna make a decision whether to defend yourself. But defending yourself is what the criminal justice system is all about.
Mr. Kiley, I really appreciate the arguments that you've made about final judgment versus finality of the proceedings, and I think it is an important question, but I want to understand one of the consequences of your position. Are you saying that if a person does avail himself of his appellate rights, he is entitled to receive continuing pension benefits even after conviction, after sentence, until such time as the appellate process is exhausted? If the conviction is affirmed on appeal, is your client responsible to disgorge the pension payments that he has received between the time of sentencing and the time of affirmance of conviction?
The answer, Justice Spina, is no. My client is not.
Okay, so there is a benefit to appealing, even if it were a frivolous appeal, and I'm not suggesting that this is a frivolous appeal.
Please don't.
That even if it were a frivolous appeal, one of the purposes of appealing would be to continue pension benefits that the employee, in all likelihood, would understand he would not be.
One could make that argument, and it could be argued in the legislature, and it could be argued to the governor as they're passing a law. This statute, Section 15, has come in increments. We had the first three sections. We had the 3A put in after the Ethics Commission came into place, and we had 268A2. And then we had the provisions in
Isn't
Section
15.6
4 after Woodward.
Does 15.6 play a role in what Justice Spina just asked?
Yeah, yes, the statute as enacted applies to people that retired after a particular date.
In 2009, I think.
No, 2009 is
Isn't
not
that
the
when
date.
it-
It's the provisions that were enacted in the 2011 statutes took effect only for people who retired after 2012. Mr. DiMasi retired in 2009.
So is it true, though, that if somebody were to retire today, Justice Spina's question would be answered that that person, if the conviction were affirmed on appeal, would need to disgorge?
Yeah, the answer for other people after that date is yes. And I think the court is well aware of this. As a general proposition based upon expectations of clients, changes that are substantive in the pension law tend to be made prospectively. And that was the case with respect to this provision.
Right, okay.
The statute is originally enacted with the words that you're interpreting, in no event after final conviction, followed sections 1 and 2. And sections 1 and 2 provided a mechanism that also addressed what happened in an interim period. If a person is charged with, in section 1, and they get a hearing. Chapter 1 of our battle here was the state trying to take away the retirement allowance at the point of indictment without a hearing. And Justice McCormick said, no, that can't be done. Part 2 came when there was a jury verdict. And the government went to court and said, please let us take away the pension, the retirement allowance right now. Essentially arguing the position repudiated in Woodward, in footnote 8. And again, here Justice Sanders said no. When you look at the statute as a whole, it provides mechanisms, and it has provided increasing mechanisms as time has gone on to deal with each contingency. So the horrible that the government might assert here in the future based upon a decision in DiMasi cannot apply to people other than those who retired prior to the date in consideration here. So there's no ongoing consequence, so to speak.
Mr. Conley, could we come back to your argument about the definition of final conviction?
Certainly.
You basically rely on the U.S. Supreme Court case Griffith versus Kentucky. Is that the one?
Well, Griffin, and there are a whole series of cases on which I rely, Justice, yes.
Okay. And you say that we shouldn't pay attention to Woodward because that was dicta, right? So my question to you is, I know that the Commonwealth says that that's not the case, but you rely also on Augustine. There's some language in Augustine.
I do.
Well, that's dicta, isn't it?
Yeah,
So,
yeah, and I want to be very clear on this Woodward point. I don't quarrel at all with the premise in Woodward footnote 8. The question that was before the court in Woodward was, is there a statute of limitations? Is it 6 years? And then the footnote deals with the situation that there was being advanced that if a 6-year statute of limitations existed, then it had expired because the jury verdict had occurred more than 6 years earlier. Sentencing had not, jury verdict had. Footnote 8 properly deals with that question. A conviction occurs in the criminal context at the time of sentencing. Final judgment for appeal purposes occurs at the time of sentencing. The argument that it occurred at the jury verdict that the government relied on in phase 2 of this case was repudiated in Woodward properly. The question is, in this case, is a different one. What's the proper measure of finality, final conviction? And I assert, Justice Hines, that there are 3 standards that suggest to you the right test for finality is not finality of judgments for appeal purposes, but the other line of cases, Augustine was the penultimate one. You had another decision on articulating a new rule later in December of last year. The Supreme Court cases, and I say there are 3 reasons, 3 maxims that take you there. This is a penal statute. You said so in Kalados. It clearly is intended to punish. It avoids a result that would be absurd. It would have been absurd throughout the many years of history of this statute. And that is when we were young, or even younger, from 45 till the 90s, criminal business was done in the Commonwealth, in the district courts. We hadn't had the federalization of the 90s. We hadn't had the proliferation of cases in the superior courts. And we had a 2-tier system. In Wilson, the case that's on footnote 9 on page 25 of my brief, this court said that a verdict in the 2-tier system wasn't enough. That's the way the statute operated throughout its terms, its tenure, and from until Woodward came along and we properly disposed of the question that was before the court in Woodward, there was never an interpretation of this statute that triggered forfeiture in advance of finishing appeals. In Mr. Woodward's case,
but that doesn't necessarily help you, does it?
I hope so.
Because,
Can I just make one last statement on that?
Sure.
In Woodward, the forfeiture process started 5 years later,
right.
after his appeals were over.
Well,
I'm sorry.
Finality means 2 different things. It really depends on the context.
Absolutely.
Yeah, I mean, we have rescript opinions and we have opinions after rescript.
Absolutely. And I'm arguing that final in this sense if you want to use the word final to modify conviction in this context, in the light of Woodward, then final has to mean something other than a judgment of conviction, a final judgment that is appealable. And again, the principles that take you there, penal statutes, avoiding the absurd, avoiding the constitutional infirmity, all argue for the discussion, the determination of final for which I am advocating. I see my time is up.
Yeah, just to be clear, the 3 points you were arguing is penal statute, which I assume means the rule of lenity applies, correct?
And strict constructionism, Mr. Chief Justice.
Okay, then the second was that this was in the context of a two-tier system, and then the third was avoiding the constitutional.
In my reply brief, I address it. You have before you this Betancourt case that argues based on Bajakian, I think it is.
Bajikagian.
Bajikagian. There's a question of excessive penalty to the extent moving forward that you are taking in cases like this a pension that is earned a retirement allowance away that is earned over a period of many years. There is a lurking constitutional question that you're going to resolve in Betancourt, I think.
Okay, but it's one that you've not argued. In your brief, I think you said that you have not argued that here.
I don't argue it directly. I do argue, I do not make an argument for Mr. DiMasi that is not based on statutory interpretation. I've not made a constitutional claim here. I think the principle of the cases is that you interpret statutes narrowly to avoid the constitutional issue.
Okay, thank you. Thank you, counsel.
Thank you.
Thank you.
Good morning, Your Honors. David Marks, Assistant Attorney General for the Board of Retirement. Let me just address this very last issue first. It's a little silly, frankly, to say that you should interpret this question of final conviction for purposes of the application of the statute across the board to avoid a constitutional issue that Betancourt raises that is an individualized problem. The problem of excessive fines is individual, and it's unconstitutional, perhaps, in individual cases. So it doesn't make sense, and there is no support for this proposition, that you should interpret a term of general application in a way to avoid constitutional issues that are only raised on an individual basis. But setting that aside.
Mr. Marks?
Yes.
I want to make sure I understand your position. If the statute says that the pension benefits may be, there's some different words we could use, either suspended or, let's say, terminated, as of the date of sentencing, and there's an appeal, and the defendant prevails on appeal and the sentence is vacated, are you saying that in those circumstances, the defendant would not be entitled to recoup the pension benefits that had been retroactive to the date of suspension?
I don't say that. No, because
so he can recoup them?
He would, because there is no conviction.
Okay.
If his conviction is overturned on appeal, there is no conviction. Therefore, he's entitled to his retirement allowance.
What, I'm changing topics somewhat, but I don't understand your justification for not having returned the contributions that Mr. DiMasi made. How can you wait until the end of this litigation? Why didn't you owe it way back?
Well, it's a difficult situation, and this is why. First of all, you have this, the nature of Section 15, this court has always said, is that it applies automatically by operation of law, it's mandatory, and the board has no discretion. So the question is, what does the law require? Now, admittedly, in this case, the board decided that it would allow him to keep the payments he had already gotten and to pay him the remaining accumulated total deductions.
Well, when you say decided, they had to repay the remaining accumulated deductions, didn't they?
Well,
Isn't this under 15.4?
they had to pay them upon final conviction. The question, by going to court, right, Mr. DiMasi raised the question of when is final conviction? And the implication of his argument is that in his case, he says, if you accept his interpretation of final conviction took place 2 years later.
Yeah.
And during those 2 years, under his argument, he would be entitled to 2 more years of retirement allowance payments, and then payment of the remainder of his total accumulated deductions. The problem is if he won the case and he gets 2 more years of retirement allowance payments, if the board had paid him his total accumulated deductions, he would have had to repay those back to the board so it could be put back into his annuity account so they could make the retirement allowance payments, because a retirement allowance is made up of the total accumulated deductions that the member has put into the system. That's placed in an annuity account. It earns interest, and it's made up of a pension paid by the government employer. And those 2 streams of money are what make up a retirement allowance.
Can I ask you this, though? All right, I understand that, but let's assume that we rule in your favor with regard to the meaning of final conviction, and therefore you would owe Mr. DiMasi the $93,753, but would have owed it to him on the date, essentially, when you terminated his pension. Shouldn't there be an interest calculation for the last, how many years? 4 years?
Well, there are 2 answers to that. The first one is no, because the statute itself says you get return of total accumulated deductions.
But if we were to conclude in your favor, that would mean essentially you're holding something that you should have given to him. All right? So the interest would accrue as of the time that you were improperly withholding the money.
But
if you decided randomly not to well, we're going to wait until a court orders us to pay this money, or wait until we choose to do it. I mean, there's no interest due?
No, the
For that
statute
period of
says,
time, after you absolutely owed it.
well, his lawsuit raised the question of whether it absolutely was owed. The case was pending before a court to decide. 4.5 months after the board decided, the appeals court came down with Flaherty. Flaherty stands for the proposition that upon final conviction, the convicted public employee is entitled to no retirement allowance, none whatsoever, that they are entitled to a return of their accumulated total deductions, but that is offset by any retirement allowance payments the member had received. So at that point, there's even more uncertainty in this case as to what Mr. DiMasi ultimately would be entitled to be paid. So under all these circumstances, keep in mind under Flaherty, if it's mandatory, automatic by operation of law, he owes the board money because he has already been paid more in a retirement allowance than his accumulated total deductions. So the lay of the land here has been uncertain almost from the beginning.
So what happens if we rule in your favor now? Are you going to pay the $93,000?
Well, it depends. It depends what you say. First of all,
Are we deciding Flaherty here? Is that part of this? We have to decide whether that's good law?
well, if you don't, then it is good law. And arguably, the board has to follow Flaherty because it has no discretion, because 15.4 is mandatory and automatic.
What
So
What would have happened if you did pay Mr. DiMasi his accumulated earnings? If you had paid them and you won on appeal and he passed away, how do you recover the money that he paid?
Well, I will admit,
Or the money that you paid him?
there was always, that is one of the concerns lurking here, is that whatever he got paid, perhaps erroneously, it would be difficult for the board to recoup. And keep in mind, the board has a fiduciary duty to protect the money. It's protecting the total accumulated deductions in part for him. He's arguing he's entitled to 2 more years of retirement allowance. That retirement allowance is going to come out in part from his total accumulated deductions. If he got it and went off and spent it and then won the case, where would the rest of the money come from?
Well, you would give him the pension portion of it. You wouldn't give him the accumulated deduction
Well,
portion.
I admit there might have to be some arithmetic going on, but it makes it much more difficult because there's a pot of money that the board is entitled by law to draw on that no longer exists. Moreover, that money is also available for the board to use to invest, to earn interest for other members. So given the uncertainties in what he was arguing, what the law required at the time, the fact that there was judicial proceedings going on, the fact that Flaherty was decided, which throws even more uncertainty into the mix, it was prudent of the board to hold the money, it wasn't going anywhere, they still have it, until a court, in this case, this court, ultimately decided.
So if we don't agree with you and say, that, at least as to the interest portion, how much interest would Mr. DiMasi be entitled to?
Well, I don't know the precise answer to that. I assume the interest would be required under the Herrick decision, which says that the person is entitled to the actuarial equivalent of what he would have received. The problem is that if,
What's that mean?
I'm not sure what that means, it is supposed to represent something resembling what the person would have received if he had been given the money originally, right? The problem here is that the actuarial equivalent of his total accumulated deductions is arguably the total plus 0 interest, because that's what the statute says. You get the total accumulated deductions with 0 interest.
Could we go back a minute to the 2011 amendment of the statute? You say in your brief that the legislature was merely affirming what was already in place. That just struck me as a little disingenuous. Why would they need to do that? And specifically say that it doesn't apply to pensioners who retire after a certain time?
Well, they would need to do it because there was a lot of uncertainty in the law. This case was pending. There were other cases that raised this question. When is final conviction? What amount of the retirement allowance is forfeited? And so clarification of this was crying out. So that's why the legislature did it. The board has always been consistent about when is final conviction. The board, in this case, earlier moved to suspend payments pending final conviction. But the board has never taken a position as to when is final conviction that is different than what this court decided in Woodward. After this court decided Woodward, the legislature essentially ratified this court's decision of what final conviction means under the statute by amending the statute 3 times without changing the words final conviction. Moreover, in section 15.6, the legislature used the words final conviction again. So this is the best argument for stare decisis. Keep in mind what you're doing is interpreting the language the legislature used in the statute. It's not 1945 anymore. And since this court's decision in Woodward, the legislature has essentially said, we're adopting that definition.
Well,
Well, they read your decisions, and
yeah.
they may not listen to them, but they are presumed to be aware of them.
Let me go back a little bit. Flaherty applied section 6?
No, Flaherty was decided after section 6 was inserted into the statute.
When did Flaherty
But-
himself retire?
This, I don't recall.
I mean, did Section 6 apply to him? That's what I'm trying to say.
No, section 6 did not apply to him, but the appeals court was aware of section 6 because it existed, but it interpreted the section 4 as it existed before the amendment. So Flaherty stands for the proposition that as it is applied to Mr. DiMasi, he may not be owed any more money, and he may have to repay what he's been paid beyond his total accumulated deductions.
If I recall correctly, we denied further appellate review in Flaherty, is that right?
Yes, and the U.S. Supreme Court denied cert. Yes.
So essentially, you're saying that we have to, if we rule in your favor, we have to essentially review Flaherty to determine whether or not he's entitled to these payments, and therefore entitled to the return of the amount that he's put into the system.
I think it would help the board if you did that.
Really, it's not argued that way.
Well, look,
I mean, your view is that Section 6 does not commence as of the time that you're saying effectively that although Mr. DiMasi is not covered by Section 6, that Section 6 did nothing more than incorporate Section 4, and therefore it's of no legal consequence?
well, what I'm saying is that Section 6 didn't change the way Section 4 applied to a person's entitlement to a retirement allowance.
Try my question. Pragmatically doesn't mean that Section 6, it doesn't matter, that even if there was never a Section 6, it would still be applied in the same fashion.
Yes, yes,
And the legislature essentially was simply clarifying
That's
what
right.
was always the law.
that's right. And this court in,
Is there any legislative history to indicate that we don't have to do this, but we're going to do this anyway?
no, but the legislature was certainly aware of confusion on this question. There was no question they were trying to clarify what the law was. This court in Bonomo has said something very similar. In Bonomo, the court said that upon conviction for a violation of the laws applicable to one's office or position, the person forfeited his entitlement to any retirement allowance under Chapter 32, Sections 1 through 28. And this court emphasized any. Now, the issue in Bonomo was whether the person was entitled to retirement from 2 different systems, and this court said, no, you're not entitled to any, from any system. But the fact that you emphasize the word any implies that, and all the language of Section 15 implies that what is really intended is that the person receive no retirement
Now,
allowance.
your time is up, but one last question, unless the others have questions. Section 6, the effective date, did the legislature say this is retroactive?
No, the Section 6, the legislature said, applies to people who retire after April of
So
2012.
why would they have done that if it was meant to apply to everyone?
Well, it wasn't the only section that they did that, but I do think that there is a concern of applying changes in the retirement law to people who retire after the changes.
You're telling us that it was not a change, that's Section 6 at least of that statute was not a change.
That's right.
So the legislature could have said,
Well-
except for Section 6, it applies prospectively, but Section 6 doesn't change anything, so that can be applied retroactively, but that's not what they did.
To be precise, it is a change. It's not a change in effect, but Section 6 says that the retirement allowance, essentially it says the retirement allowance that is lost is any paid from the date of offense. And what I'm saying is that originally, the way 15.4 was written, it meant any retirement allowance at all, without regard to when it was paid. But the effect of 15.6 is the same.
All right, I guess and I said it, one more question. If we are looking to the intent of the legislature in 1945, with regard to, are you saying that we shouldn't? We should
No.
look to it because we should look to it in view of the post-Woodward?
That's right. Keep in
changes?
mind, the board did what this court said in Woodward. The board made no error here whatsoever. This court said what final conviction is. And since this court said that, the legislature, and you're interpreting the words of the legislature, after Woodward, the legislature 3 times amended this statute. Not only did it use final conviction again, it inserted it again in another section. This is the best reason for this court to stick with its decision in Woodward.
All right, thank you.
Thank you, Your Honors.